And welcome to episode 3 of the Principium Pod. I'm Sean Wilkie, Director of Digital Services at Principium.
And I'm Dennis Prahl, President at Principium. In this episode, Sean and I will discuss ICANN's general meeting last week in Abu Dhabi and any important developments for intellectual property rights holders. In particular, we wanted to cover 4 areas. Number 1, the European Union's General Data Protection Regulation coming up next year and its effect on WHOIS. Number 2, the timing of the next new gTLD round. Third, the whole .Amazon issue. And finally, the status of the Rights Protection Mechanisms review.
By far the biggest topic looming over the ICANN community is the European Union's General Data Protection Regulation, or the GDPR, and how this affects WHOIS data for domain names. The GDPR replaces the EU's current data protection directive and was created to increase consistency and predictability of EU citizen data protection. Obligations for businesses and organizations considered data controllers include security breach notifications, new requirements for documenting IT procedures, risk assessments, more protections for transparency and consent, cross-border data transfers, appointment of a data protection officer, etc. This affects not only parties within the EU, but if you are a company from outside of the region, such as the US, and you process any EU citizen data, you must comply with the GDPR. Enforcement of the law commences on May 25th, 2018. Because WHOIS data includes the personal information of domain owners, the GDPR clearly conflicts with the current open nature of WHOIS access. With every tier of the domain supply chain controlling specific elements of WHOIS data, including ICANN, registries, registrars, escrow providers, and resellers, the entire community must find a GDPR-compliant solution. The current state of WHOIS is simply unsustainable. For contracted parties, the GDPR affects their current agreements with ICANN, suppliers, and customers due to data transfer requirements. This directly affects domain owners' rights to expiration notices, WHOIS data verification, and registrant validation. Without available WHOIS data, how do registrar and registrant transfers function? ICANN requires contracted parties to retain all domain registrant data for at least 2 years. GDPR nullifies this. It also overrides the pending WHOIS privacy proxy accreditation requirement for registrars in its current state, which would have been very helpful for brand owners. VeriSign's transition from thin to thick WHOIS for .com and .net is now delayed and will likely not even happen due to the GDPR. Even the domain aftermarket will be greatly affected, as it will be much more difficult to contact owners of domain names. Domain monitoring services such as Principium's Domain and WHOIS Watch will also need to vastly change without WHOIS access. Speaking of brand holders and monitoring, Dennis, what does the intellectual property community need to consider with the GDPR and domain enforcement? It's pretty clear that the EU is prioritizing the right to data protection over consumer trust, law enforcement, and IP protection.
It's interesting, Sean. I mean, WHOIS is a fundamental tool for brand owners to enforce their rights against domain holders who abuse the system. So people who use it for infringement, for phishing attacks, and any sort of illegitimate uses of the domain name system. You have to be able to figure out who is behind the domain name to take action against them. If that falls away, it's going to be increasingly difficult. It's already difficult, but increasingly difficult for brand owners to try and enforce their rights on the internet against domain holders. And although the GDPR has been around for about 2 years, unfortunately, it hasn't really escalated to the top of ICANN's agenda until this last year. So everyone's scrambling to try and come up with a solution within a fairly short period of time to try and meet the needs of GDPR, while at the same time meeting the needs of the users and the constituency of ICANN.
Yeah, it seems like last week in Abu Dhabi, ICANN stated that they'll propose an interim solution for contracted parties. In the near future, I think it's important to note that whatever interim and permanent solution ICANN creates will most likely be in the best interest of ICANN and ICANN alone, and not necessarily protect the interest of the contracted parties and even the community at large. ICANN also encouraged these parties to propose their own WHOIS alternatives and noted that they will actually defer compliance action against parties not fulfilling their WHOIS obligations while demonstrating compliance with the GDPR. We're already seeing this with two Dutch gTLDs, .amsterdam and .frl. This advice will indeed create more chaos if every registry, registrar, and escrow provider proposes their own solutions. So it'll be important for these parties and the greater community to come together and develop a consistent solution for WHOIS and fast. Going forward, what we might see is, just thin WHOIS across the board, which doesn't display any personal contact data, privacy proxy data as the default contact information in WHOIS, perhaps tiered access, which is already being tested with the Registration Data Access Protocol, or the RDAP program, and a review of some EU ccTLD registries for possible solutions that might already be complying with GDPR. So, Dennis, any other thoughts about the future of WHOIS for brand holders?
I think it's very uncertain, Sean, at this point. I mean, we have legal opinions that ICANN solicited that they introduced last week in Abu Dhabi. We have a legal opinion that the Intellectual Property Constituency obtained, and one or two others that are going around. Everyone has every law firm seems to have a different take on how to satisfy GDPR in the WHOIS realm.
Yeah, it's quite a mess. So the next topic are new gTLDs. Even though applications from the first round of new gTLDs are still pending, work is underway to prepare for the next round. Did the meeting provide any clues regarding when round 2 will commence?
Not really. I mean, the first round is still in progress. For example, .radio just opened up their sunrise period as recently as October 31st, 2017. So there's no real news on timing. There have been some comments in the past that maybe 2020 at the earliest would be it. But again, ICANN is still reviewing how the first round went. And until that process is complete, they really don't want to open up the second round because they want to make sure that whatever corrections they need to make in the first phase, will apply to the second phase as well.
So another big pending gTLD is .amazon. It pits the geographic rights of South American countries within the Amazonas region against the intellectual property rights of Amazon, the corporation. The latter applied for the new gTLD, and ICANN rejected it due to objections from the Governmental Advisory Committee. But the application was revived due to an independent review panel's decision. While Amazon, the corporation, has attempted to work with the affected governments to find a mutually agreeable solution, last week in Abu Dhabi saw representatives of both Peru and Brazil, among others, completely rejecting the company's overtures in a public session. Why has this battle lingered, and how do you see it ultimately playing out?
Yeah, this is a very interesting issue right now before ICANN. If you thought it was hot outside in Abu Dhabi last week and at the conference, it was really heated on the inside when it got to the .amazon issue. It basically arose because there was no prohibition on geographic area names in the original playbook for the first round. And when Amazon applied for .amazon and some foreign equivalents, the Governmental Advisory Committee went to the ICANN board and said, we have a problem with this based upon Peru and Brazil's objections, basically. And the ICANN board said, we're going to reject it. Later on, Amazon appealed that to an independent review panel, which this past summer came out and said that they were overturning the board decision because the board gave too much deference to the GAC advice and should really reconsider the .amazon application. So the Governmental Advisory Committee was very exercised at this meeting about its rights to affect ICANN policy. And we'll see where this goes. At this point, the board has asked the GAC to come back with for sort of a merit-based position paper on why .amazon should be rejected before the next meeting in March, and the board will take that up. But this is really showing the tension between the efforts of some governments and the GAC to affect change within ICANN and its processes, sometimes outside the mechanisms that have been set up by ICANN as a multi-stakeholder corporation.
Yeah, it's almost like it's an existential crisis for ICANN, really.
It is, and it plays to the tension of, how much should governments have control over ICANN?
So One ongoing policy development process, or PDP, applicable to brand holders is the review of all rights protection mechanisms in all gTLDs, including the UDRP, URS, TMCH, and of course, the PDD-RP. Where does this process stand, and do you expect any material changes to the status quo?
So yeah, this is a big study that they've undertaken, as a result of trying to look at a second round of new gTLDs. This is studying in two phases the rights protection mechanisms. Phase one addresses those RPMs that were implemented for the current new gTLD round in 2012. So that's the URS, the Trademark Clearinghouse, etc. And they aim to complete that study by the end of 2018. Then phase two, which they might start just before that, is to study the UDRP, and that's been around since 1999. So depending upon the outcome, it could have serious effects on domain name enforcement tools for brand owners. At this point, they're trying to collect data, trying to collect a lot of opinions about what works, what doesn't work, and it's really up in the air what will happen once this gets to works its way through the committee and all the recommendations to see what changes will come out. We're of course hopeful that what will come out on the other side, at least for brand owners, is more effective tools to take action against brand infringers. But it could equally come out that they weaken the tools that are existing, and we have to rely on more traditional methods to enforce brand trademark rights, such as the courts.
Well, as usual, there's quite a lot happening at ICANN. Thanks for your time, Dennis.
Thank you, Sean.
We'll be closely monitoring these important issues and keep you updated with any new information as they become available. That'll do it for this episode of the Principium Pod. We hope you've come away a little more knowledgeable
and a little more informed about the latest trends in intellectual property protection.
Thanks for joining us, and please visit principiumstrategies.com for more information about our IP protection services. Take care. The Principium Pod is brought to you by Principium Strategies. Principium has been at the forefront of intellectual property protection for more than a century. Covering more than 180 available jurisdictions worldwide, our International Trademark Watch pairs state-of-the-art, proprietary customized software with our network of trademark analysts, who then review the results to ensure that you receive only those which will be relevant to your protected brands. Not only does Principium focus on Trademark Watch, but we also have an entire division focused on domain management, maintenance, and online brand protection. Using Principium for your domain and online brand management can save your organization expense in domain registration and management costs while providing unmatched service, protection, and security. We apply our legal, business, and technological expertise to relentlessly protect your brand. To know more, visit principiumstrategies.com. Principium Strategies, the evolution of brand security.